'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Mike D coming down for sure.
Having looked at the different kinds of legal systems that there are in the world, as well as what law is, I think it's useful just to give a bit of perspective to the development of the common law system. That helps us understand why we might have some of the various classification systems that we do for law. It also will help us later when we come across some rules of law, and I can come back to this idea about the development of our law and why it works the way that it does. So again, I really want to emphasize this is foundational knowledge that helps you understand things later during the unit. But what I wanted to start with is a review of where our common law system actually comes from. So as I've already mentioned, our legal system is based upon the British legal system of common law. That begins in its current form with the Battle of Hastings in 1066. What we can think of is before that, Britain was really made up of all these separate little chieftains who would run their own customary law. So there'd be customary law with local courts that was not unified. Then what we have is the invasion of England, the establishment of a monarchy. And so what William the Conqueror does is he appoints judges, right, who hold courts around the country. So when you think about it, what he's actually doing is instructing judges to give consistency in their judgments and then sending them out to make judgments. And in that way, it starts providing a uniform system of law across this area that before then had quite different approaches to how they might settle legal disputes. Gradually, this system gets more formalized. So some of the things we've noted is that, Henry II continues sending the justices out, but they start recording facts and decisions and reasoning. So this is where we really start to see the development of the doctrine of precedent, which we'll come to in the next segment of the unit. As well as this, we see a change in society where we start to see power over a number of centuries move from the elite nobles to the common people, ordinary people. That starts with the signing of the Magna Carta, which limits the power of the king. Over time, this limitation of power leads to the development of Parliament. Notice in England we've got two houses, the House of Commons, right, and the House of Lords. And the idea was to balance the power of the nobility with everyday citizens. Okay, so this system evolved as the power shifts from the nobles to a democratic system of government. And there is a gradual shift in the powers between the two houses till we end up in the current situation where the crown is largely a figurehead. So over this period, we've gone from an absolute monarchy to a democracy where the crown is largely a figurehead as they are today. In the same way, we see the courts developed. We have these judges who report back to the king, start to get formalised into facts and decisions. So we see that idea of the rule of law start to develop. However, one of the problems with following rules and only following rules that are written down is that it can become inflexible. So what we start to see as a result of this inflexibility is the development of a new body of law, equity in the courts of chancery. And I mentioned that in one of the early videos before. So it starts to try and establish more justice in the legal system, balancing justice with the certainty of pre-recorded decisions that must be followed. Now, both of these systems are fused into one form of law. But that's where we end up where we do, where we have two sources of law, right? Judge-made law still occurs, plus we also have legislation that comes from Parliament. As time has gone on, there's more emphasis on legislation because it reflects the change in our government to a democratic form of government rather than an absolute monarchy. So that's a very brief kind of historical overview of the development of the common law system. And you can see over several centuries, at different points, we see a development in our legal system that leads to quite different applications of law and distribution of power within society. Now, what's interesting as part of that, it means that we have these kind of areas of law which are based upon different philosophies. So again, I really want to emphasize this stuff is foundational. It's kind of, you've got to learn it so that you can then understand things a little bit later. We try to minimize the detail in this subject because we're not going to be practicing lawyers. But having said that, it's important that you conceptually understand what's going on. If you can conceptually understand how our legal system works, it means later on, when you have a legal problem, you can probably understand what the problem is a lot better, right? If you don't do that, then you're just bound to take people's advice, which might or might not be the best thing for you. I'll get into that in the next module that we actually do about the difference between legal advice and business advice. But if you understand these concepts and these different classification systems, it can be very useful when interpreting legal advice. So traditionally, there have been one way to classify law is through two broad categories. Public law, which is the relationship between the citizen and the state or the government, right? So we want to concentrate on things like constitutional law, administrative law, criminal law, and taxation law. In all these instances, it's not another person who you're in conflict with. You're in conflict with society or the government in this case as a reflection of society. That's very different to private law. Private law is the relationship between two people within the community. And so tort, contract, property law, company law, commercial law, they're about the relationships between individuals, and that's considered private law. And traditionally, no one has a right to interfere in someone else's private law. So if you breach a contract with me, for instance, let's take a third party. Let's use an example so you understand the conceptual difference. If we have two people, person A and person B, and they have a contract, and just say person A breaches their contract, right? So they've done the wrong thing under the agreement, and legally they've done the wrong thing. Because it's private law, person C or even the government can't enforce this breach. They can't take action against A because the issue is between two private citizens. Okay? There are legal remedies for B, but no one else can interfere. Now, let's take a different situation, criminal law. And person A attacks person B. Okay. So while there are private law implications, for instance, this would be a tort because A has hurt B, so it would be a tort, a kind of law. In terms of criminal law, what actually happens is it's not technically up to B to enforce assault charges. So even if B doesn't want to enforce to have the law enforced against A, it's not up to them. It's up to the state, right? So the Crown prosecutes. Now, I know what you're saying. They drop charges when the person doesn't want to proceed with them, etc. That is a different issue. That's an issue of evidence and whether you can prove it. And there's also a balance in the administration of government about respecting the victim. But technically speaking, it's not up to the person who's attacked, right? It's not up to the person who's attacked. It's society enforcing the law against this particular individual. That's the critical element. That's the kind of main difference between public law and private law, right? It's not about the relationship between individuals, private law. It's about the relationship between the state and the individual in public law. Within that, there's lots of subclassifications. Here are the 6 areas that we want you to know what they are. By knowing these 6 and where they fit as public or private law, we can test your conceptual understanding. They're also probably 6 of the most important areas of law for you to know in a business context. So we've got constitutional law, which looks at the relationship between levels of government, so between the state and Commonwealth government and between the government and its citizens. We've got administrative law, which tells you what the government can do. And so they're both examples of public law. And then in terms of private law, we've got torts, and we're going to deal with negligence, which is a kind of tort. Contract, we do some contract. Important that you recognise intellectual property, right, is a form of private law. And company law, which again we're going to do as part of this particular unit. So they're the classification systems in terms of public and private law and specific areas of law that we'd like you to know. Now the other classification system, so this is kind of a different classification system, right? Just like you could classify animals as whether they're like mammals or not mammals, you could also classify animals about whether they have, whether they walk on 4 legs or 2, right? Or whether they have legs or don't have legs, right? They're different classification systems. So think about that. This is a different classification system and an important one in our legal system, the difference between criminal law and civil law. So as we said, criminal law is a kind of public law. It establishes criminal offences and penalties, right? The state prosecutes people, and the standard of proof is beyond a reasonable doubt. In contrast, in civil law, that's about the relationship between citizens. A civil action is commenced by the person claiming to be harmed, the plaintiff, not the state. And you've got to establish your case on the balance of probabilities, not beyond a reasonable doubt. Very different standards of proof. And examples would be contract law and tort law. What we find is that the administration of law changes. You would have seen criminal law processes on TV and popular culture. So here are some of the differences between civil and criminal law. The parties, what we call the parties, who has the burden of proof, who has to prove their claim. It's the person bringing the case. In civil law, the person harmed or the plaintiff. In criminal law, the Crown. How much proof do you need? What's the standard? Balance of probabilities versus beyond reasonable doubt. Are there juries? Sometimes there even are in civil cases. We won't go into that detail, but just be aware there can be juries in civil cases, and there's not always a jury in a criminal case, right? It's only for major offences that we have a problem. And then we have an outcome, a result and an outcome. Really importantly, the outcome from criminal law is punishment, right, for breaking the law. In civil law, like breach of contract, we don't punish people. Okay, it's a remedy, and we'll get to that. It's a remedy. What you're trying to do is provide a remedy to the person harmed. Okay, you're remedying the harm caused in civil law in the relationship between people. Important conceptual issue. You're not punishing someone for doing the wrong thing. You're putting the person who has been harmed back into the position they would have been in if they hadn't have been harmed by the illegal act of the other person. Whew. So, just like there's different ways we could classify animals, there's different ways we can classify law. You can classify law as public versus private, criminal as opposed to civil, case as opposed to statute, and within case law, common law as opposed to equity. Whew. So you've really got to think about how these classification systems work. What makes it very confusing is that the same word is often used to describe different aspects of law and our legal system. And this can be very confusing for people the first time they come across it. So here are some of the key examples of the repeated use of the same word to mean different things. Common law can mean a national system, like Australia's national system of governance. It can mean judge-made law within a common law system, or it can mean the specific area of judge-made law called common law. Civil law can mean a national legal system like we would find in continental Europe, or it can mean the private law of individuals within a common law system. So for instance, civil versus criminal law in Australia. The words legislation, act, and statute refer to the same thing, a law made by Parliament. Wow, so I know that can be confusing to people, all that terminology, etc. But hopefully as we go through, you'll see the value in understanding that as I refer back to it. And it's not as confusing as what it might first seem. So with that first element out of the way, what we're going to do now is tune into Australia's legal system and look at some of the key features of our legal system as opposed to legal systems in general.